Goldman, and today I'd like to talk to you a little bit about how criminal cases are handled from the standpoint of trial lawyers. We here at Goldman & Associates, we're essentially trial lawyers. And what we do is we defend our clients in all manner of ways, some of which require actually having a trial just like you see on TV, where there's a judge and a jury and there's evidence and there's posters and there's videos and there's experts. And this is what's called trying a case in front of a jury. Many times, in order to aggressively service the defense of your client, you have to take a case to trial. Now, is it desirable to take a case to trial? Sometimes it is. Sometimes it isn't. I'll tell you one thing. If you're charged with a case where it's your word against somebody else's, that's not a case where the prosecutor is likely to dismiss it. That's a case where if they don't offer you a legitimate way of resolving this case beforehand, you're going to have to take that case to trial. And when you do, you're going to be faced with a decision that every criminal defendant is faced with. Do I testify or do I take the Fifth Amendment? Remember, the Fifth Amendment gives people the right to remain silent. So you don't have to testify if you don't want to, and your silence cannot be used against you. But ladies and gentlemen, I want to tell you something. Having done this for 25 years, I will tell you that that is a rule of evidence. It's not a rule of society, and it's not a rule of reality. Don't engage in the fiction that the jury will look at you and say, well, obviously he's innocent because he hasn't been convicted yet and he has the right to not defend himself. Don't engage in that fiction because that's not what happens. In reality, the people who make up those criminal jurors, it's usually 14. It's 12 and they pick 2 alternates. Those people will typically take a look at you and see whether or not they think you're guilty by the way you look, by the clothing you wear. Do you have tattoos? Do you have a piercing? Do you have something that gives them an impression that you're already guilty even though the prosecutor hasn't proved one iota of evidence against you? Nothing. That's why it becomes important to decide, do I testify or not? And I will tell you this, in more cases than not, in cases that we have tried and we have spoken to the jury afterward because lawyers are permitted to do so, we are categorically told, it was good that you put your client on the stand. We wanted to hear what he had to say. The juries want to hear that. And you could be offended by that and say, what do you mean you wanted to hear it? I shouldn't have to prove anything. The Fifth Amendment says I don't have to prove anything. I can remain silent. But there's a practical reality. And you have to face that reality. The system doesn't always work 100% the way people hope it will. And because of that, you have to take certain practicalities into account.